You've reached FIT TV. Stick around. We'll be right back.
Soon we will be alright. When we're gonna make it work. Too many people living in a secret world while they play mothers and fathers. We play little boys and girls. When we're gonna make it work.
New York State legislators finally passed what the other 49 states already have, a no-fault divorce bill. This is the first divorce law reform passage since the major sweeping changes in the 60s and 70s. New Yorkers have suffered through a myriad of archaic family law consequences since then. Child dysfunction in its wake for families in transition has been the testimony. This could be the beginning of the process of change. Imagine, New Yorkers, you no longer have to commit perjury for grounds for divorce. The subject is no-fault divorce, and I have with me to discuss this Rachel Green, who's a mediator and a collaborative attorney out of Brooklyn, New York. Welcome, Rachel.
Thanks, Chris. Glad to be here.
Okay, maybe you seem to know a little bit about the history of no-fault. Why don't you tell the public what that is about? What is your knowledge in that area?
Well, as you mentioned, Chris, New York has been the only state that did not have no-fault divorce, and there's been tremendous opposition to it by the pro-marriage groups, who are trying to figure out ways to support marriage and lower our divorce rate as a society.
Like the Catholic Church, right?
Absolutely.
Yeah.
And then also feminist groups who have feared that giving anybody easy grounds for divorce will take power away from women in negotiating child support, spousal support, property division, whatever. But New York has, an unusual history because for a long time, the only ground for divorce was adultery. And that's why we see the old movies where people have their ex get drunk and go to a hotel, and then a private detective shows up and takes a picture of them. And that was the only ground for divorce for a long time. So people were falsifying adultery evidence. And still to this day, you can't get a divorce on the ground of adultery without having a third-party evidence of the adultery.
Which is a very expensive way to go.
Right. And also an embarrassing way to go. So we've been left with fault grounds, which have hurt couples who are trying very hard, probably for the sake of their children or for themselves, to try to resolve things in an adult, amicable, peaceful way. And what we've been left with are that they have to allege abandonment or cruel and inhuman treatment. One person is in prison, that you can't really fake. And what couples have been using, the system as we've had it has led to people, again, needing to perjure themselves, because what couples usually have used who have been able to agree on all the terms, perhaps they've been able to work with a mediator and resolved what is their children's schedule going to be, how they're going to support their children, what they want to do with their house, and they're ready to file for divorce, and they still need to have grounds for divorce. And so if they want to file in a timely manner, they don't want to wait a year after signing a separation agreement, then what they would say is allegations of constructive abandonment, which is sexual abandonment. And they would say in the papers, the other person has refused to have marital relations with me for a period of a year. I was not under a medical disability.
Extensive language about all what happened and didn't happen, and it was all a hoax.
That's right. I was at all times ready, able, and willing to perform marital duties, etc. So because no one but the two of them could confirm that, the papers would go right through if they both agreed to file that way. But frankly, everybody, including the judges, knew that many of those cases were perjuring themselves. They were signing papers, under oath that were going to the court that weren't true. So what we have now with the new statute is to get rid of that whole pretense. As long as one spouse will sign a paper before notary publics saying that the marriage has been irretrievably broken for a period of 6 months. Then they can get divorced.
As opposed to having to be separated first with a separation agreement for 12 months, which was the New York state law.
Right. And I mean, incidentally, that ground is still there. This new statute has added a 7th ground for divorce. The other 6 are still there. So if couples want to sign a separation agreement and wait a year, and many couples do want to do that because during that year they're adjusting to all the major life changes that come with separating, and sometimes they want to stay married, or because of health insurance they want to stay married for that year, but they want their legal rights as a spouse to end, so they sign a separation agreement and they wait a year, and then after a year they can get back together and say what worked, what didn't work, and then file their papers for divorce. They can still do that. What this law will do, however, is there's a small minority of people who have been living in limbo, who have, one person initiated the divorce, as is usually the case, and the other person was so angry and hurt that they say, I am never going to give you a divorce. And there are some couples who have been living separated for years because one spouse didn't want to grant the other person the divorce.
Somewhat imprisoning the petitioner or the person who wants to be divorced.
That's absolutely right. All the years I've worked in this field, I have not been able to understand what benefit there is to society to keep people married who are not in any way married. They're living separated. They're not sharing any assets. They're not having anything resembling love pass between the two of them. And it prevents either of them from moving forward with their lives. So now those people are going to be able to just go into court and quickly file for divorce after October 12th.
One of the reasons might be, I thought it was September 1st.
No, it's October 12th,
okay,
that it goes into effect.
Some of the people might want to maintain power by holding back a person from getting their wish.
That's right.
Now, when that happens, is mediation appropriate? Because I know the bulk of your work is in mediation.
Well, mediation can help if they're both willing to come into mediation. I have had some very, very moving experiences in a situation like that, where one person is so hurt and during mediation has the opportunity to really express how painful is the loss of all the hopes and dreams of the future that they would have together, of what a raw deal they feel they've gotten, and how they want, how they've been so hurt they can't imagine their future. And I have had some very moving conversations where the initiating person really hears that and even apologizes, and there's opportunity in mediation for healing.
This takes a lot of work on the mediator's part to talk them into, or assist them, I should say, in getting what they want and remove that acrimony so that one party doesn't retract or move out into litigation.
Right. Well, I mean, in mediation, there's really an opportunity to explore what are they getting out of holding on to all that pain. I mean, as much as, you feel you've been wronged. Well, you know what? Life isn't always fair. And, you got a raw deal. It's not what you wanted. Life isn't always fair. But is it going to do you, this is where we are today. So is it going to do you any good? Is it going to make your life better to hold on to that anger and to become, just to live the rest of your life as this damaged person? Or do you want to move forward?
It's a tough lesson for a lot of people to learn.
It is.
But it's certainly a very important one. I'm
glad
you talked about that. Let's go back one more little comment about the National Organization for Women, as I understand, is against it. Several feminist organizations have been against no fault. I know one of them was the power imbalance, and one of them is the power to women. I
think they're worrying about two scenarios. One is the traditional couple, like that was the typical couple in the 50 years ago, where the husband was the wage earner and the wife was home with the children, not earning money, not building a career, and is now the less moneyed spouse. And the husband leaves the marriage for a younger woman. I think this is the classic scenario that the feminist organizations are thinking of when they are opposing no-fault divorce. Now, what I have found in my practice is that I have actually found very few couples these days who are living that traditional life. I mean, we know that there are societal reasons why families can't get by on one income anymore. So, so there are fewer and fewer of those kinds of traditional marriages. And in addition, the statistics are that about 70% of divorces are initiated by women. So I think that some of those feminist groups are a little behind the times in the scenario that they're thinking of. Mm-hmm. The truth is that the no-fault divorce is going to take away leverage from the person who does not want the divorce, whether that is the husband or the wife. The fact that under New York law, we have not had grounds for divorce if you are not the initiating person. And now anybody who feels the marriage is irretrievably broken has grounds for divorce. So that's no longer going to be, it's no longer going to be, I'm not going to give you the divorce unless you let me stay in the house for the next 10 years.
This seems like a no-brainer for a lot of people who are struggling with how to get to the point of divorce. They have to contemplate grounds, or they have to contemplate whether I need grounds or whether I need a mediator or whatever they may need. Now you have an opportunity to say, I'm stuck in a bad situation, what can I do? At least this no-fault law sets a table for making it easier for somebody to get out of that bad situation.
Right. That's absolutely true. And then the other thing is, going back to what we were just talking about, the need to heal in divorce, which mediation gives people the opportunity to do. Does it really help anybody to have the law say, you are adversaries, we are going to pit you against each other, we're gonna just hold on to that fight and make you fight more to get this done? Or do we want, as a society, do we want people to be able to resolve disputes? And certainly all the research shows that for children, the disputes, the high acrimony, the conflict, the yelling, the active fighting between the parents is the one thing all the experts agree hurts children.
I've been looking at those statistics for years, and that's why I mentioned in my opening that the testimony for the dysfunction out of New York State law, not just New York State, divorce law, when you get divorced through courts,
right? That
the acrimony itself, the adversarial nature of that process, always, for the most part, causes dysfunction in children. The statistics are overwhelming.
Yeah.
So this gives them a little bit of a break. Mediating is certainly a better way to go.
Certainly it is, and I find that most, many of the people who come to me for mediation have the goal of trying to lower the amount of conflict for the children. They're able to be adult enough about this to say, well, you know what, we want to part ways. I can't stand you anymore. I don't want to live with you. But you know what? You're always going to be in my life. I'm always going to be the mother of your children. You're always going to be the father of my children. And for the children, we are their two parents, and we always will be. Whether
no matter
even
what format you're in, no matter how you get divorced, you're still going to be your kids' parents forever.
That's right.
You're going to have to look at them forever.
That's right.
Let's go over some of these highlight film, the summary of the just so the public can gain the education and information. Irretrievably broken for at least 6 months, whereas before there was a 12-month period of separation by law. Is there another way to explain that? You have to swear under oath. How is somebody walking into that situation? Look, I want to be divorced. What do I have to do? We have to mention this. This is one of the one of the aspects of the summary of the bill.
Well, the truth is, Chris, that we don't know how the judges are going to interpret this. We don't know yet what forms they are going to require be submitted to the court. I assume there will be an affidavit that one of the spouses has to sign saying, in my opinion, the marriage is irretrievably broken. I was talking to my mother about this change in the law, and she was shocked that only one person had to say the marriage is irretrievably broken. I said to her, you know what? If one person believes that it's over, it's over.
How does anybody stay in a two-person relationship when one person's
Exactly. She's like, I don't know. Yeah, right.
Oh, yeah. Look at that.
But that's what's required. Now, we don't know whether, certainly if they've been separated for 6 months and they are saying, you know what, we know we're never going to live together again. That's one thing. If they haven't been separated, but they've been fighting for 6 months, what if, one person still has hope and the other person for 6 months has felt it's irretrievably
get counseling
broken?
or go to mediation.
That's certainly true.
Let's go back over. I know we mentioned it earlier on, but I want to collect the items that are necessary to have accomplished in the bill before they can go forward. That is, the issues are the ancillary issues are the equitable distribution,
Right, the division of marital property,
okay.
anything that they've accumulated during the marriage.
Okay, good. Payment of a waiver, payment or waiver of spousal support. This is subject for another show coming up soon, but the spousal support is maintenance.
Right.
And
so they'll have to have resolved
you can
that.
waive this? Is that payment or waiver?
Yes, because spousal support under New York law is not mandatory. It's called rehabilitative maintenance. So it's really only in cases where one spouse is not able to be self-supporting, and for a period of time, they'll get help from their ex.
So the new maintenance bill, which is coming up right behind this, is reason to make it more. It's still not mandatory. Judge's discretion, right?
Right.
But doesn't it make it more possible? Makes us look at the criteria. Yeah.
The new spousal support law.
Yeah.
Well, it is going
area.
to make it more possible in that you now are going to have to calculate
and face
spousal support under the formula, and then say we are not having spousal support because X, Y, Z.
Okay. We'll talk about that another day.
Yes.
Payment of the child support is another issue. That's a fixed percentages that everybody has to deal with. One child, 17. 2 is 25. 3 is 29, right? 4 is what, 33?
31.
31. 5 is 33?
Yes.
Okay, something like that. Yeah. Okay.
In Brooklyn, we don't get too many 5-children families.
Yeah, yeah.
Housing is so expensive.
In China, they have 1.0 now, right?
That's right.
Okay, custody, visitation, I guess we call it access. What about that? I mean, that also has to be solved.
Right. I mean, basically, the couple is going to have to work out these details. You know, no matter what grounds for divorce they have, they're going to have to work out how they're going to care for their children, how they're going to support their children, what they're going to do with their property and debt when they divide it. Does one spouse need support from the other? So all these issues always are going to have to be resolved in order to have a divorce. And again, we don't know how judges are going to resolve this. I mean, anytime, in my practice as a mediator, I work with couples to resolve all of these things, and all these things are the main thing that we talk about. And grounds tends to be the last subject. So now taking care of grounds is going to be easier. But all these things have to be decided in order to fill out the uncontested divorce forms and file them with the court anyway. I mean, what I've had in my practice under the old law is that I have couples who work very hard to try to reach across the table and come to agreement on all these things, and respect each other's place in their children's lives, and be fair to each other, so that they're not in a situation where where the kid knows that one parent is living on peanut butter because he or she cannot support themselves, and the other parent is making that happen. In mediation, they do tend to work more as a team. They're restructuring their family, and they're still connected. They're always going to be connected for the years that they've shared in their history.
I like to use the word creation. They're creating their own document in a transparent fashion.
That's right.
I mean, they're building something, so they both participate in a relatively equal fashion.
Right. That's right. And they work so hard to resolve all these issues. And then I say to them, okay, now we have to decide on grounds. One of you is going to be the plaintiff and the other is the defendant, and you're going to have to allege something unless you want to sign a separation agreement and wait for a year.
So that's gone now.
And now that's gone. Now we'll be able to say, okay, what are your thoughts about the timing for this divorce? Are you ready to file now? What's your health insurance situation? Certainly because of health insurance being such an expensive item now, that's a reason that I see many people decide to stay married to separate, have a legal separation, but stay married so that one can stay on the other's health insurance. So we want to look at all these factors, but if they're both ready to divorce now, we have the new irreconcilable differences.
Regarding the health insurance, is that part of the ancillary issues coming up? Because there's so many issues about health insurance that we do need to face out in front of us as mediators. And this year of separation, you can keep the other parent on the policy,
right? But
that's not indefinite, is it?
No, they can.
I mean, they stay separation for a few years. I mean,
well, they can sign a separation agreement and stay separated for 30 years if they want to, right? And stay covered. As long as you haven't filed those divorce papers, you can continue to file joint taxes, and you can stay on each other's health insurance because you're still married technically. And there certainly are people who do that for for those financial reasons, for taxes or health insurance, or religious reasons. They don't want to file for divorce. They just want to stay legally separated. And sometimes
it's an interesting state of being, isn't it?
Right. And sometimes they stay married until there's a reason to get divorced. Somebody else wants to be remarried.
Yeah. It's usually another party, right?
Right.
To break that up.
Right.
So when no one's, so that everybody knows and is clear about it, no one's inventing false justification any longer.
That's right.
Okay. And this is holding back false accusations as well. I mean, accusations in other areas.
Absolutely. It's holding back accusations that marital relations were withheld. It's holding back accusations of cruel and inhuman treatment. I mean, I recently had a couple that was divorcing, and there was an immigration issue, and so the person who was in the process of applying for a permanent green card needed the divorce very quickly, and so came up with these cruel and inhuman treatment grounds. And the other person was terribly upset reading these grounds, and they were very
embarrassed,
and but they finally said, all right, let's just do it to get this thing done quickly, because they couldn't use constructive abandonment, because then the INS might say, oh, it really wasn't a real marriage for 2 years because you stopped having sex a year ago, so they couldn't use that. They came up with cruel and inhuman treatment. But that was very upsetting and embarrassing, and I give that person actually a lot of credit for being able to do it for their spouse.
Yeah.
But it's icky.
This is interesting that the Office of Court Administration reports that there was a decline in domestic violence in states where no fault had existed previously. The 27 states showed that adopting the no-fault statute saw female suicide rates decline as well.
I saw those statistics, Chris. Isn't that so interesting? I mean, that again goes back to how the feminist groups have this one paradigm that they're looking at. And they're not looking at the idea that there could be a family where there's domestic violence and the perpetrator is trying to keep control over the wife and is saying, well, you don't have grounds for divorce. So I'm going to keep you in this marriage, and then the violence continues, or the wife commits suicide. I mean, this is These are statistics that have been borne out in other states that passed no fault. So I certainly hope we see that improvement in domestic violence and female suicides in New York. That would be wonderful.
It would be great if if it happened in other states, and like you say, it happens in New York. That's fantastic. But I found it this was the only place that we could go to. It looked to me, because I'm doing legislative work for 20 years, the feminist groups have stopped, for instance, the joint custody bill, for instance, from going through. They've always been against that. Some similar reasons: the protection of women and women's right to an attorney, due process, and all that other stuff. But I noticed that the argument broke down many years ago on shared parenting, but they still never got a shared parenting bill through. This, to me, is language just to justify them.
Yeah.
I mean, I know how strong their lobby is in Albany.
Right.
I've been doing this for a long time, so I'm familiar with it.
Right, especially in New York, they have a very strong voice.
Yeah. But I mean, it's said that I hope this not only breaks this paradigm, I hope it breaks a paradigm on custody, because most of and you said that to me, that most of your people divorcing are asking for joint custody.
Yeah, most of the couples who come to mediation are asking for joint custody, and they're able to recognize that even if they hate their ex, that their children still need to have a mother and a father in their lives, and that they'll do better with two strong parents.
See, those statistics have been known for a long time, Rachel.
They have, but Dr. Joan Kelly presented some new research just to us in New York at the New York State Council on Divorce Mediation last May, that have just borne out how the role of fathers is even more crucial than we ever believed in children's lives, and children who have more contact with their fathers, and just fathers who attended parent-teacher conferences showed 15% increase in the children's grades in school.
Right.
So the question is, I think the feminist groups have been opposed to the presumption of joint custody, because they still believe that the mothers are the primary parents, and so the parenting time will be taken away from them. Again, I don't see that as necessarily the case with all of these two working parent families.
You have to look at Kyle Pruitt's work. Kyle Pruitt, and I can't remember the other guy's name now. He was a feminist at one time, but he had said that if you had to give custody for normal, healthy children, if you had to give custody to a child over 12, male or female, that the father would be a better custodial parent in a general way in terms of thinking forward rather than protecting.
Mm-hmm.
If you did it at age 4, I would say the opposite was true, and he indicates the same thing too.
Right.
So I believe, and I do believe, because it's not just me who sees this, but everybody says that the children do seem to do better with the mother in the earlier years.
Yeah.
And they do seem to do better having contact with the father in the later years.
Right. Well,
and
certainly,
that's why there's two parents.
That's right. No, there are studies that show that mothers and fathers play differently with children,
sure.
and children really benefit.
They
from
learn risk
seeing
from
those,
fathers,
that's
that kind
right.
of thing. Sure,
that's
I know.
absolutely true. As a general principle.
We can call it general, but to me it's reality. I mean, that is definitely something that should have happened a long time ago, and it's still being held up.
Yeah.
Okay, you have you're a lawyer, and you've decided upon mediation. We're pretty much done with the no fault issue. You've decided to become a mediator. What made you choose to do this work?
Well, I really have, I think I have it in my bones in a certain way. I practiced as a litigator for 2 years at a firm, and it just made no sense to me. I'm the kind of person who feels like I hate being in conflict with people. I hate fighting. And so to me, the fight always had costs that most of the time exceeded whatever the reward was at the end of the fight. And I certainly saw that in, I was doing, corporate civil litigation, and big corporations were spending more money on lawyer fees than was in contest between them. If on day one they had said, let's just split this 50-50, I worked on several cases where they would have come out ahead. And after they spent $700,000 on legal fees over a number of years with a big law firm, doesn't make any sense. And in fact, corporations have started using mediation much more as well.
Yes, and it continues to go in that direction.
Right. In the divorce arena, I think it makes even more sense because you've shared an intimate relationship. If you have children, you're going to have a continuing relationship. You're going to have to attend the high school and college graduations together. Mm-hmm. You're going to be at the hospital at the birth of your first grandchild, and the wedding. The wedding, hopefully will come before the grandchild, but not always. But you're going to be in each other's lives, and so if you can find a way to heal the relationship rather than just keep focusing on the conflict and build the conflict and make it bigger, I think in the long run you're better off.
Yeah, thank you very much, Rachel Green. I also use that as my moniker of my show, that divorce is about relationships, and relationships can't be adjudicated. Bringing a relationship to court just doesn't fit into the puzzle of common sense.
Right.
Thank you very much for the show. I appreciate it.
You're very welcome.
Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every single week. Of course, we always invite all opposing views. My name is Chris DiMaggio, and thank you very much for watching FIT TV, and we'll see you again next week.